All attendees joining us. Great. Okay. Good morning, everyone. My name is Bruno Monteiro, and I'll be one of the moderators of this webinar alongside my colleague Paula Granier. We both work at Validity Foundation, which is an international NGO headquartered in Budapest, which uses the law in innovative ways to advance the rights of people with mental disabilities. I hope you are all excited to participate in our webinar on access to justice for persons with disabilities. This is a component of the project meeting of two EU-funded projects coordinated by Validity Foundation. One of them is Child-Friendly Justice, which is funded by the Rights, Equality, and Citizenship Program. And the other is called Voice for Justice, which is co-funded by the Justice Program. Both have in common that they're about access to justice for people who can find it hard to access justice in a positive and meaningful way. And both also aim to advance and help make practical the rights set out in the CRPD and the EU Directive on Victims' Rights. And both these projects also aim to put children and adults with disabilities at the center of the research process and the creation of any practical tools that aim to benefit them. Just to give a bit more context, so both projects are ending their first year of implementation, and this webinar will be an opportunity to reflect on what has been done, how these projects fit the current international context, and learn together with you and panelists on what both projects should prioritize to ensure access to justice for both adults and children with disabilities, regardless if they become involved as victims or suspects of committing a crime when they become involved with the justice system. So before I give the floor to our great panelists, I'm just going to go over very quickly the housekeeping rules. Just ask for your patience. So first and foremost, you probably already noticed that this webinar is being recorded. Hope everyone is comfortable with this. Whenever you're not speaking, please do keep yourselves muted. And whenever you'd like to speak, please use the raise hand option. If you're not familiar with this feature, I invite you to look at the bottom center of your Zoom screen. You should see a button. That says "Raise Hand." When you press it, either myself, Paula, or Zofia will call out your name and allow you to speak. If you're a participant, we will simply ask you to unmute yourself and call out your name if you'd like to ask a question. Participants, you also have the option to just write out your questions in the chat box. So feel free to use it. And in any case, we will aim to make this webinar as accessible as possible and give everyone here the possibility to speak and participate. If there's any concerns or if you need any assistance, just feel free to just write a message to myself, Paula, or Sophia. And so, of course, we'll always be attentive to the chat box, but of course, we just ask for your patience if we don't see your question right away. And finally, well, as you're probably used to webinars at this point, but if there are any technical difficulties, we just appreciate your patience on this, and we'll give you instructions to overcome this. So with all the housekeeping rules taken care of, then I would like to give the floor to our first speaker, Anne Campbell, who is one of the co-executive directors of Validity Foundation, and who will speak on how our two projects, validity strategies, and the current international context. So Anne, whenever you're ready.
Thanks, Bruno, and good morning to everybody who has gotten out of bed this morning, all of our amazing panelists to join us here today, and all of the participants who've come to join us today. As many of you who are already familiar with Validity and our work know, we do our best to put our legal expertise to use serving people with disabilities as they fight for justice and for their rights. But justice is hard to define, and it's even harder to actually achieve in reality. We know it when we see it, but we see it far too rarely. What does justice look like for a survivor of rape in a psychiatric hospital? What does justice look like for a person with intellectual disability who's denied the right to make decisions about their own health because their legal capacity is restricted? What does justice look like for a child who's denied the right to family life because she's detained in a group home? People with disabilities can provide answers to these questions if they have the right language, tools, and opportunities to speak up and be heard. Accessing court systems by filing cases to assert their rights can be one very effective way of doing this. Yet the barriers and impediments placed in the way of people with disabilities who try to access courts are oppressive, multifaceted, and systemic. Facing these barriers against the odds is an onerous task, and one that people with disabilities often face alone, without any support from the justice system that is supposed to serve them. The Convention on the Rights of Persons with Disabilities gave a language of rights to persons with disabilities to articulate the inequality and discrimination that they experience. This is a legal language with binding force that they are entitled to rely upon through the courts. In Europe, several EU laws provide additional protections and rights of relevance to persons with disabilities. In particular, the Charter of Fundamental Rights, but also, for example, the Victims' Rights Directive for victims of crime, and the Child Procedural Rights Directive for children who are accused or suspected of crimes. These laws operate in the context of implementation of the EU strategy on victims' rights, the new EU disability strategy, and the new EU gender equality strategy. And they're complemented by regional instruments such as the Istanbul Convention on Violence Against Women. But how do these legal instruments and rights actually help persons with disabilities access courts in practice? And do they actually help achieve justice for them? Together with partners across Europe, Validity is running 2 multi-country projects that seek to identify how the Victims' Rights Directive and the Child Procedural Rights Directive can work together with the CRPD to improve access to justice for persons with disabilities in practice. The first project is being implemented by partners on the ground in 7 EU member states and focuses on improving access to information and effective communication for victims of crime with disability. We're soon wrapping up a research component of that project, identifying the main legal, policy, and practice gaps and opportunities for persons with disabilities to use the Victims' Rights Directive in courts. In parallel, we're developing a set of practical tools for various justice system professionals and other stakeholders that will help them meet their obligations to ensure the rights of victims of crime with disabilities are respected in justice processes. These include the right to understand and be understood, the right to information, and the right to be heard. The second project takes place in Bulgaria, Italy, and Romania, where partners are right now developing practical models to make criminal justice systems more child-friendly for both child victims and children accused or suspected of committing a crime. These models focus on children with disabilities, children deprived of parental care, and unaccompanied minors, and seek to improve the conduct of individual assessments designed to understand their needs so that they can more effectively participate in the court process. They're being developed taking into account the findings of almost a year of research into the existing standards and practices in this regard in each of those countries. Both projects are still in full swing, but preliminary findings confirm some of what we already suspected and have shed new light on previously poorly understood challenges. As we know, people with disabilities are often isolated in institutions, psychiatric institutions, social care institutions, group homes, and others. And in these places, it can be difficult, if not impossible, to access legal advice or representation, or to access any independent complaint body, including the police. Intimidation and reprisals for complaining are real issues. For persons with disabilities living in institutions or in the community, a lack of alternatives and dependence on existing services or caregivers can make it impossible for them to complain when a crime is committed against them. When people with disabilities do manage to complain, their stories are considered not credible or are dismissed based on stereotypes and prejudice. This person is too disabled to give evidence, or this person isn't capable of understanding what happened to them. And many people with disabilities simply do not have access to information in a format that they can understand about how to complain, what happens during an investigation, what is their role in court, and what they can expect from the justice process. Services that are supposed to support victims of crime, including by providing information, lack the knowledge to serve persons with disabilities, or in some cases actively exclude them. But more than this, our partners are discovering that there's a blank space between social care structures where crimes occur and policing and criminal justice structures where victims are supposed to find redress. Crimes against people with disabilities may not even be recognized as crimes at all and are understood to be normal patterns of behavior. Alternatively, they may be labeled as simply abuse or bullying and dealt with entirely outside of the criminal justice system. Within the justice system, there's a systemic failure to recognize disability. Professionals deny ever encountering a victim with a disability, and victims themselves may not want to disclose that part of their identity. In terms of individual assessments to enhance participation by children in criminal proceedings, there's a fundamental misunderstanding of the purpose of the assessment, which can often be seen instead as a means of obtaining evidence or of punishing the child. In some cases, translation of the relevant EU law into the national legal system is inaccurate, further undermining the protection of rights. In addition, the projects kicked off in the early months of the pandemic. Institutions were shut down, denying access to family members, but also to lawyers and independent monitoring bodies. Services for persons with disabilities were almost universally reduced or discontinued. Reports of increasing domestic violence and violence in institutions were common around the world. Courts were shut down or experienced substantial delays as cases were effectively frozen, and countries experimented with a variety of e-justice measures and attempts to administer justice remotely. Over the two webinars today and tomorrow morning, we'll explore some of the key normative standards relating to access to justice for persons with disabilities, with a particular focus on access to information and effective communication for victims of crime with disabilities, and on child-friendly individual assessments for children in criminal justice systems. We'll look at some of the challenges, but also, and perhaps more importantly, some of the potential solutions, how they might work in practice, and how they can have a real impact for persons with disabilities in justice systems. The absolutely outstanding speakers this morning will take a practical view of the types of procedural accommodations that can open up court processes for persons with disabilities, and will share their extensive experience of how to effectively provide information to victims of crime that they need to understand and participate in justice processes. We'll hear about the role of intermediaries who can support investigative authorities and courts to identify and meet the needs of victims of crime with disabilities as required under the Victims' Rights Directive. Tomorrow morning, we will examine how and when crimes against persons with disabilities can be understood as hate crime, and how social media can be used to secure justice for victims and their families. Finally, we'll hear about and discuss redress for violence against people with disabilities, social justice, recognition, and legal remedies. So with that, I will wrap up and hand back over to Bruno to kick off our first session with two exceptionally knowledgeable and outstanding experts in the field, Anna Lawson and Gabor Gombosch. And I very much look forward to hearing from them and the other eminent experts that we have over the next couple of days. And I hope that we will have a lively and active discussion to share our experiences, thoughts, struggles, and successes with all of the participants here. Thank you. Back over to you, Bruno.
Thank you, Anne. I hope this background was useful for all participants, especially for those that might not as familiar with both our projects. So as Anne mentioned, we will now begin with our Disability and Justice panel. It will be an opportunity to hear both from you and our experts on access to justice, and also hear a bit more about the impact of COVID-19 on accessing justice for persons with disabilities, and what are the necessary procedural rights that should be implemented to ensure access to justice, such as the right to individual assessments and right to procedural accommodations. There will be a Q&A at the end of this session, and we very much welcome any and all questions you might have. Our first panelist is Professor Anna Lawson. Um, Professor Anna Lawson works at the University of Leeds and is an expert in the area of disability rights and law, human rights, accessibility, and um, and Anna, whenever you're ready, you're free to begin.
Thank you so much, Bruno, and thank you to Validity and Bruno and Paola for the invitation to be with you today. I'm really very grateful to be here and looking forward to hearing the discussion. And yeah, so I think the other thing I want to say is just thank you to all of you who are doing the research on these projects, because it's incredibly important work. And although I've only read some of the summary emerging findings so far and listened with great interest to what Anne said just then, I'm looking forward to hearing much more from you during the day about what you're finding. So I'm going to talk for about 15 minutes and I'm mostly going to focus on the victim perspective. And I'm going to address three main issues. So the first one is barriers, which will cover a lot of the same ground that Anne just covered, actually, but I want to make a few reflections on those at the same time. And then assessments, which Anne also touched on, and data sharing. So maybe there was less on that in Anne's, but basically it's picking up on those issues that Anne identified and maybe reflecting on them a little bit more and perhaps provoking some discussion from you for our later question and answer session. So first of all, the barriers. So I'm not going to try and present an exhaustive list of barriers to accessing justice, which victims of crime experience. As I said, I've read with great interest the summary of your emerging findings, and they do capture quite a lot of these examples of barriers. So they broadly include access to information about how you can, about whether you're the victim of a crime, about what to do if you are, and about how the court process works, about how you can access a lawyer, and then information from a lawyer about what your specific case and progressing that. So yeah, information I think is of two broad types. There's the more generic type of information and education and socialization as just part of helping people understand what they're entitled to and what they're entitled to complain about, what types of behaviour towards them amount to crimes. And that's often something that's been missing for disabled people, particularly people with intellectual disabilities and psychosocial disabilities, and particularly people who are spending a lot of time or living in institutional settings or spending a lot of time in social care settings. Some of the barriers are then around education, socialization, understanding, awareness, but other barriers are around the accessibility of that information and the accessibility of communication processes, or the failure to make adjustments for specific individuals around those communication processes. And there's been a few studies around how just interacting with a lawyer can be incredibly difficult, or interacting with the police can be incredibly difficult for disabled people, particularly because lawyers often don't have any training in making their language more accessible, in taking longer, if that's what the client needs, to explain the situation to them. Yeah, and just making adjustments to the timings of interviews and the way those interviews are carried out. Okay, other barriers concern the fact that very often incidents are not treated or recognised as crimes if a person is disabled and within a social care context. And again, there's been a little bit of research on this, but there's still a need for more. So the tendency in a lot of countries and a lot of settings is for police not to investigate it if there's a complaint, because the person who has been victimised is in a social care context. The assumption is that the care providers, the people in charge in that institutional setting, will do the investigating and sort out the problem. So often harms which are done to people which in other situations would amount to crimes are not treated as crimes in the same way, and they don't even enter into the criminal justice system. Other barriers are that even if victims understand that a crime has been committed against them, they experience various barriers to making complaints. And this is often because of fear about the consequences of making a complaint, which may be based on previous experiences of trying to make a complaint. So in one research project, which I was involved with for the Fundamental Rights Agency a few years ago, there was a couple who lived in Leeds, the same city I live in, who both had intellectual disabilities. And they went out one evening, came back, and the window of their flat had been broken. And they phoned the police, and instead of investigating whether anybody else had committed a crime against them, the police spent a lot of time questioning them about whether they damaged their own property. So that's one example, but I've also know of other people who have resisted making a complaint about very serious ongoing domestic abuse because of the very well-grounded fear that her child would be taken away from her. She would cease to have access to her child if she made the complaint and it led to a separation between her and the abusive partner. And then again, very often there are accounts of disabled people who make complaints about crime, and instead of the crime being investigated carefully, as it would be if somebody else had made the complaint, the focus is put on the disabled individual in question, which may result in them losing some of their liberty or all of their liberty indeed. So putting them in more protective settings with implications for their freedom. And then there are probably the more familiar barriers around accessing the legal system, the justice system, concerning denial of legal capacity. So if you're regarded as not having legal capacity, you don't have the standing to engage with the legal system in your own right. And that obviously creates huge access to justice barriers. Crimes are often not prosecuted because of the fear by the prosecution service that the victim won't be able to give evidence that's reliable. I mentioned that one. And we have quite a lot of examples of that in the UK as well as in other countries. So if most of the evidence is going to be from the victim, and that victim is somebody who the prosecution service, imagine the jury or the judge, will not trust because of their disability, then often crimes, very serious crimes, don't get prosecuted at all. Even if they do, the victim then has to go through the ordeal of giving evidence and having their reliability questioned very publicly. And then I think more generally, there's been a tendency in the justice system to look at what special measures are needed for the victim in terms of what's needed to protect them, protect their safety, instead of thinking of those as from the perspective of what's needed in order to ensure that they have equal access to justice. So there's a focus on protection instead of on equal engagement in the justice system. And that goes for defendants as well. So the CRPD is extremely important, as we all know, in giving us a tool to challenge a lot of these problems with the justice system. Article 13 is the article which is specifically on access to justice and therefore which receives particular attention in these types of project and contexts and discussion. But it really is important not to focus on Article 13 at the exclusion of the other articles. Article 12 on legal capacity is obviously relevant to the barriers some of the barriers I mentioned. Article 16 is particularly relevant to victims of crime, the right to be free from exploitation, violence and abuse. And I think Article 5 is also really important to remember, just this whole idea of equality and that's and accessibility. Those are fundamental underpinning principles and values of the Convention, which apply across the board, including in the context of access to justice. Okay. So just a small reflection on those barriers before I go on to think about more barriers relating to COVID specifically. A lot of those barriers stem from an attitude towards a disabled person as being the source of the problem. So instead of looking at the justice system and the way that that's operating as the problem, the tendency has been to think of a disabled person as the source of the problem. So it's easier to exclude them from the justice system. It's their fault in a way that they can't access the justice system in the way it operates for other people. The fact that their condition means that they can't communicate in the same way as everybody else means that they have to bear the brunt of that, the consequences of that in court, rather than the court changing. So a lot of these barriers really go back to this sense of the disabled person being the problem, which obviously links to the whole individual or medical model of disability, rather than a more social model or human rights approach to disability. So it's a very good illustration of the way that those approaches, those attitudes play out in practice in very disabling ways, which cause huge injustice and exclusion. So just thinking about COVID, and Dan touched on this as well, but to pull that out a little bit more, COVID-19 has meant that a lot of people have been living in much more isolated ways than they did previously. And even within institutions, that's had an impact because many institutions and social care settings have shut their doors to the outside world. So there's much more limited access to inspections, to visits from family or friends. So much greater degree of isolation within institutions and social care settings, but within the private home as well. And I think it's important to remember here that a lot of disabled people, not enough, but a lot do live in private homes. but many of them, a hugely disproportionate number of them, experience domestic abuse in private homes. This has been a big concern for everybody during the pandemic, the increase in domestic abuse and the increased difficulty of making complaints about domestic abuse. And that's going to impact disproportionately again on disabled people, given the types of barrier that we already knew existed, the ones I've already just mentioned. The way court proceedings work has changed in many countries. So in some cases there have just been delays, but in many countries there have been attempts to move a bit more quickly towards e-justice than was planned. So there were often plans, I think in most countries, to move towards greater reliance on e-justice and video hearings, but those have been accelerated much faster than was anticipated. So it's been quite a big experiment the last year and a half. And I think in many ways we're still, the research you're doing is really timely because we haven't got much data on how that experiment worked yet. The work that you're doing will contribute to information about what happened, what's been happening over this past year and a half. There has been some research on this in the UK by the Equality and Human Rights Commission. It identified some difficulties with video hearings for disabled people, and they focus specifically on people with intellectual disabilities, psychosocial disabilities, and neurodiversity. They found that it was harder for people who harder to identify whether somebody needed support in the first place, because they weren't coming into contact. Services weren't, the justice system professionals weren't coming into contact directly with the parties in the case. It also found that where people did need support, it was harder to identify exactly what type of support that would be. And that was partly because of unfamiliarity with the video system, not just for the parties, the disabled people concerned, but also for the professionals involved. But I think also it's really important to remember here that we have a lot of information before COVID around the particular difficulties which disabled people face around accessing the internet, accessing technology, and the huge digital gap which exists between disabled people and non-disabled people. And yeah, there are that impacts again, particularly on people with certain types of impairment. Visual impairments is one, but also people with mental health conditions or psychosocial disabilities, and people with intellectual disabilities is another. So big challenges and questions around using video hearings and e-justice systems and the impact that that's going to have on disabled people, and not enough data as yet. So moving on to the second issue, the second and third issue are much quicker. Assessments. So Anne mentioned this, assessments of what? So there's a lot of talk about assessing the needs of somebody, of a disabled person in court, but I think it's worth really thinking hard about that process. So first of all, what are we trying to assess? Well, the justice system isn't a medical profession. It's not trying to, it shouldn't be trying to diagnose somebody's medical conditions, although actually a lot of the assessments do end up becoming extremely medical. What the purpose of the assessments in the justice system should be is to identify the support needs of that individual. What does that particular individual need in order to communicate effectively with and participate effectively in all aspects of the justice process. The recent guidance from the UN Special Rapporteur on access to justice makes it very clear that this type of assessment should not be based on medical need. So it's not enough just to have a diagnosis. So if there is a diagnosis of that person's condition, the assessment shouldn't stop there. That's not what we're trying to assess. That in many ways is irrelevant or very much background to the assessment that we need. So the assessment needs to be about needs, about support needs. And really, I think it's important to look at General Comment 6 here of the CRPD Committee on Article 5 and the right to equality, and what it has to say about the processes for assessing reasonable accommodation, sorry. It stresses things like there should be a dialogue. It shouldn't just be a one-way process. There should be a dialogue with the person about what their needs are, what will help them. And that's important to take into this, this assessment process too. Okay, so I know there's a lot more to say on those assessments, but we'll have time to discuss that in our later question and answer discussion. Finally, on data sharing, this links to the previous point about assessments and also about barriers. It's important that there should be data that's kept as a matter of routine by courts about what type of support was needed, was provided to particular individuals without retaining too much data about that particular individual. So keeping information about the type of accommodation that was provided, the type of procedure that was changed in order to accommodate the needs of that person, without all the personal information of that particular victim or defendant. Yeah, sorry to labour that point again, because I think I'm muffling it. We need to keep data about adjustments, accommodations that are being made, without all the personal data of that individual. It may also be useful to keep information about the type of impairment that a person has, but without their name, and just in the broadest category of impairment type. And so that's the kind of data we need to be kept on a routine basis. Why do we need it? We need it in order to find out who's using the system, to keep a track of who's using the system. And all the indications from particular research projects on the justice system are that a huge number of disabled people are using the justice system, even though often justice professionals don't realise that that's the case. So we need this data in order to keep in the forefront of everybody's mind who is actually using the justice system. The fact that so many disabled people are using the justice system, or should be using the justice system actually. And that will help us to tailor the justice system to its users. Any system or service should be tailored to the needs of its users. This isn't just a case of adapting to the particular needs of a particular individual. The whole of the justice system needs tailoring, needs adapting, needs changing to reflect the needs of a huge portion of its users. Okay, I think I'll leave it there. Bar one point, which is about assessments, I forgot to mention that although a lot of a lot of attention is given to the need for individualized assessments in the justice system. I think it's really important to remember that many people have lives outside the justice system, and their support needs will have been assessed quite carefully for other purposes. So if they consent, and only if they consent, information that's been collected about their support needs in other contexts could be shared with the justice system, which might result in better data about their needs, and reduce the burden on the individual of going through another assessment process. So that's another type of data sharing, but on a much more individual level, and it's subject to the consent of the individuals, obviously. Okay, so thank you very much.
Thank you very much, Anna. It was great to hear you speak about the many barriers that persons with disabilities face in accessing justice, and how COVID-19 has had an impact on accessing justice, especially from the perspective of victims. Um, Now I'd like to introduce Gabor Gombos, um, who will speak from the perspective of defendants. Gabor Gombos is a well-renowned independent disability rights defender, and is a former member of the UN Committee on the Rights of Persons with Disabilities. Gabor, whenever you're ready, feel free to start.
Good morning, everyone. It's a real privilege to be part of this webinar, and especially on the same panel as Anna Lawson. My disability is psychosocial disability, so possibly you will forgive me if my 15 minutes will be a less coherent presentation of a subject. I have been thinking about what core message, or at most 3 core points of message, I should deliver in such a presentation. And then I started thinking about whether it's accidental that access to justice as a dedicated article is right after the legal capacity article, or it is a more built-in logic behind that. And before losing my point, I am telling you the answer I have. It is not accidental. You can look at access to justice through various glasses from various perspectives. One possible perspective is that basically access to justice is nothing else than your legal capacity in the field of criminal and maybe other justice systems. So then the question is, what is needed and what is not needed, if you like, what is counter-warranted in the process, in the establishment of justice. As Bruno said, my focus will be more on defendants than on victims, partly because I have some limited personal experience on that side, and partly because I do think that while I am not able to give a correct definition of what justice is, certainly justice should be something which is not only about the victim. It should not be only about the defendant. it should be about a situation, about an event, about harm, about consequences. And at this point, I should also share my conviction that Article 13 of the CRPD, in conjunction with all the other articles Anna mentioned, will not be and cannot be implemented properly without shifting the justice system's focus towards restorative justice and restorative techniques in justice. When can we say that a justice system is accessible for persons with disabilities, in particular, persons with psychosocial disability, intellectual disability, and autism? Evidently, all the conventional accessibility measures should play an important role. Now we know that accessibility should be realized progressively. That means that accessibility, full accessibility, effective accessibility obviously requires resources, not only financial resources, but human resources. It requires shifting the minds of the participants, including the professionals who participate in the justice system. And it does take time. Now, we know that in situations when accessibility is not yet there, what the claimant still may, and as an advocate, I really encourage them that they should, refer to is reasonable accommodation. Let me share a story with you. When I came back from New York, from the session of the ad hoc committee, which adopted the CRPD, and I started talking to my Hungarian peers, many of them told me, Gabor, this is a real disaster. This reasonable accommodation idea is a disaster. And I felt really shocked because I, as one of the many thousand architects of the convention, was very proud that CRPD makes it clear that reasonable accommodation is an immediate obligation of the state parties. So what is wrong with it in the eyes of my peers? And of course it was about the word reasonable. And then come all the questions and dilemmas, who decides what is reasonable, where is the burden of proof, etc., etc. I would like to draw your attention to the text of Article 13, which otherwise I very seldom do. I am not a really textual human rights expert. But in this case, I think it's very telling. It talks about accommodations without the qualifier reasonable. When I was still in the committee, especially when we were working on General Comment number 1 on legal capacity, we had to think about whether this was an accidental thing that in Article 13 the language is not about reasonable accommodation, but accommodation in general. And our conclusion was that it was not accidental. What do I mean on that? Now, I can tell you only a few central issues here. Anything which may be necessary for either the victim or the defendant or witnesses, actually, to make sure that the proceedings will be non-discriminatory, will be de facto equal to similar proceedings with non-disabled actors, should be provided. There is no space to make delicate judgments on whether an accommodation is reasonable in the ordinary sense. Of course, irrational accommodations shall not be provided, that's clear. But anything different than that, which can be arguably necessary for more than what I could call a reasonable justice, which is a nonsense, should be provided. Now, Anna Lawson mentioned a very important aspect of reasonable accommodation, namely that reasonable accommodation is not a one time event. It's a dialogue. It should be an ongoing dialogue. Now, what about the accommodations required under Article 13? I do think, it's my personal opinion, though, that the same applies here. It should be an ongoing discourse, dialogue, which should also have, or at least could have, an impact on the justice system for all. I would really claim that CRPD, with its approach and normative framework and obligations on the states, is not only of and for persons with disabilities. It is really about the humanization of the justice system and making the justice system accessible for all persons. Justice system and its symbols are scary. I remember that the first time I went into a court building, I was the elected representative of an NGO, and I had to go to the court to register that NGO. And still, my heartbeat was above 100. I felt very unsecure because in my culture, in my country, in my historical context, courts were not really about justice. It was about power. And for many people, I think in many jurisdictions, it is the same until now. So if a person who is in a disadvantaged situation has to enter the court, physically or virtually, it doesn't matter too much, and faces all the symbols of power, it is disabling. So I would say that when anyone thinking and planning about access to justice for persons with disabilities should really start with thinking about focusing the power. The power should be on justice. And when those who developed our current justice systems decided that the power of the court should be emphasized through symbols also, they did not mean that the power of the judge or the power of the judiciary. They meant that the power of state to facilitate justice. Thank you.
Thanks so much, Gabor. And I apologize for the noise here. Looks like they're doing some renovations. So now we're going to have a quick Q&A session. Do any participants have any questions they'd like to ask Gabor and Anna? Anything at all, or else I actually have one. Well, got one question. So this is a question for you, Gabor. It's a question from Stephen. So what is in your view, what is your view on the insanity defense? Should it be abolished, or will that have negative effects on persons with psychosocial disabilities?
Well, I can clearly say that, in my opinion, insanity defense is in contradiction to the CRPD. So from a strictly legalistic point of view, the answer is that it should be abolished. So now the justice side is that what will be the consequence of the abolition of insanity defense? It may depend on the country, on the culture, on how and for what purpose insanity defense has been used. I think it should be abolished. It should be abolished in a very close consultation with all the experts concerned, including DPOs, including individual experts with disabilities included. It is a radical paradigm shift, I think, in our approach what to do with people who committed a serious crime, and according to the old paradigm, should not be punished because they were insane. They could not really decide about the consequences, etc., etc., etc. It should be replaced by a supportive system. It should end up in a justice where the offender will face the same criminal consequences as their non-disabled peers. And again, it should be used as a good opportunity to humanize the entire criminal justice system. But it should be criminal justice, it should not be mental health justice.
Thank you so much, Gabor. Because of the noise, Paula will take over for me. Paula also has a question.
Thank you, Jofi. I was muted. Yeah, thank you, Bruno. Yeah, we can't all time renovations and traffic to suit a webinar, so thank you. So I have a question, Anna, for Anna and Gabor, which is about what supports you think would be needed for remote hearings? And also, how could that be assessed, and who would do that type of assessment? Yeah.
Shall I start?
Please, Anna, yes.
Okay. Okay, thank you. I just wanted to thank Gabor as well for such, it's always so fascinating hearing his thoughts and inspiring. But so on this particular issue, I think it needs to be grounded in the more general approach to assessing the type of support that people need. And I think there needs to be flexibility about that for the particular person's circumstances. And it may be that for some people, online hearings isn't really appropriate. So I do think, you know, not having it online should be an option as well. So I think online shouldn't totally replace the physical type of hearing. And as to who should do it, I think the person concerned needs to be very involved, centrally involved in that process. And I guess who should do it is the same people who should be involved in assessing what types of supports and adjustments are needed for people, for disabled people, or anybody else really. As Gabor says, it should be for everybody, the justice system, and many of us, whether we're disabled or not, might need different ways of doing things to participate better. So I think that the people who do that system should be probably the same, although they would need specific training around online issues. Who they are, though, I think is maybe something beyond what I've really thought about. I'm not sure whether it should be a social worker or somebody in the justice system, but yeah, somebody who has expertise in support needs, not necessarily medical needs in support.
Thank you, Anna. I think that's very, very helpful. And we know that more and more hearings are being held remotely in different ways, and we know that quite often judges have different approaches to it as well in different countries. Gabor, would you like to add something on that?
Well, I can really second everything what Anna said. Flexibility is crucial. And I may add one point, which I wanted to speak about in the main part of the presentation already. And it is that one critical element of accessibility is that all the actors, all the participants of the proceedings, including the victim, of course, and the defendant, should be very well aware, should be informed about what is going to happen. For people with autism, this can be, you know, a sine qua non condition for effective participation in the procedure. But for everyone, for all persons with disabilities, it is really important to enable them also to be flexible. And they can be flexible only if in advance they understand what, in possibly what order, what sequence is going to happen. Now, in case of online proceedings, the usual procedural introduction to what is going to happen should be complemented with IT introduction. So information technologically, what is going to happen. I think in the past month, you know, or a year in this COVID period, we all felt the embarrassment we feel when something goes wrong with the Zoom, for instance. We don't know what to do. We end up in a panic. Now think of a person with psychosocial disability. A minor technological difficulty may end up in a huge distress, which may disable an effective participation in the procedure.
Thank you, Gabor. Yes, yes. I think we're familiar with ending up in a confused tiz about wrong remotely, and they still do, no matter how experienced we become. Things still go wrong. I have a question from Katarina Fitzko. Zsófi, can you bring Katarina in to ask the question?
Oh.
Oh my gosh, Katarina, welcome.
Hear me?
Yes, we can hear you very well.
Hey, welcome. Okay.
Your voice.
Yeah, I was wondering, how do you think part of some of the support, since people, institutions experience violence also from staff, and violence there is very normalized, and I believe be overlooked. But yeah, how do you think that we could, develop this sensibility when in transition to community?
Thank you, Katarina. Actually, you were breaking up a bit, so I'm just going to repeat what you wrote, that it's about how could deinstitutionalization be part of developing some support for victims, particularly, I think, when institutions are such an environment where violence takes place, intimidation, other behaviors which become normalized in institutional settings, which are criminal. And we were, so the question is about that connection between institutional settings and support for victims.
I don't know whether, Gabor, would you like to go first on this one, or shall I?
I would be happy if Anna could start.
I think that's a really good question, and I totally agree with you that this kind of socialization, education, that first type of barrier that I mentioned is something that needs to be really embedded in initiatives to move from institutions to community living, and that. But I think it shouldn't wait till there. I think it should be happening in institutions. Well, hopefully deinstitutionalization will be happening immediately, but I think, there's no reason why this has to wait for any of the other processes around deinstitutionalization to be ready. This should really be something that can be pushed for within institutions immediately, because it shouldn't cost anything. It's a change of culture, which I know is sometimes harder to achieve than anything, but it's one that doesn't depend on anything else happening in order for us to try and push for that culture change to happen.
Yeah. Thank you. We know that this is one of the trickiest, or I mean, one of the really trickiest areas. As you said, culture change is difficult, and this normalization of behavior is very hard to tackle. Gabor, would you like to add something?
I think I agree with what Anna said, and the key message is that we immediately need to respond on that, and progressively, but without delay, we should deinstitutionalize our societies and the justice system as well in that respect. And this should, again, I think, go hand in hand with restorative aspects of justice as well. When victims, or actually even defendants, with disabilities are institutionalized, then normalization is a very tricky question. And I even do not know what it means. I think it should not mean normalization in the orthodox meaning. And instead of normalization, I again would prefer the word humanization.
Thank you, Gabor. Thank you. And thank you, Katarina, for the question. Anne, I know you have a question, but can I ask you to hold on to it because we will go to the next session. Gabor and Anna, just thank you very, very much. This really set it really set the scene for us, I think. You really brought out many of the issues that we're facing and trying to tackle. And it was, it was really inspiring to hear your contributions. And I have to say, it was wonderful to hear you together as well. I'm so happy that you were both able to make it and appear on a panel together. So thank you so much. It's up to you whether you want to stay. You'd be very, very welcome to stay, but I do understand that you may have other commitments, in which case, thank you. If you're staying, then please do so, because I think we have some very interesting presentations coming up now. We'll hear now from Ana Ferreira from APAV in Portugal, who've been doing some really amazing work providing information to victims of crime. This is really groundbreaking work as I see it. It's really comprehensive, and it's really trying to cover many, many countries in the European Union in the light of the Victims' Rights Directive. It's making real some of those rights that are there, which people without disabilities often have difficulty accessing as well. And after that, we will hear from David and Charlotte, who will talk about the Advocates Gateway work. I will talk about that more. I'll introduce them after Anna has spoken. Anna, can I hand over to you now? Thank you.
Thank you. Thank you very much, Paula. And thank you, Bruno, as well. Thank you, the Validity Foundation, for the invitation. It's a pleasure to be here, especially following such an interesting panel. I was asked to basically address the topic of delivering information to and communicating with victims of crime, which is a part or a component that I mentioned of providing support as well. And doing so not only, but also by introducing to you a tool that we, APAV, have developed 10 years ago already, and keep updating and improving for the victims of crime and expanding to different countries. That's the InfoVictims. Well, I will show you the website, but there are other materials, and I'll speak a little bit more about that. On these issues of information and communication, I will speak in general terms. However, I will refer often to examples from the Portuguese reality, just to illustrate some of the issues that I want to address. And I will be asking, actually, if I could later on share the screen to show the website. Is that possible? I don't know if that's possible. Paula, it is? Okay, great. So I didn't see here. Okay, fantastic. So without further ado, just to briefly introduce, APAV is the Portuguese Association for Victim Support, and we are a non-governmental organization that provides support to victims of crimes, of all crimes, all types of crime, and all crime victims, and supports in terms of legal support, legal advice mostly, psychological support, emotional support, social support, and practicalities. And we have a set of networks, including specialized networks for certain types of victims, including, for instance, a specialized network to address issues of children and youth victims of sexual violence. And the need for this specialized support comes precisely from the view of there are victims that have added barriers and added necessities that we need more expertise on, and specialized units to work with. And this serves to me to introduce the fact that we are just starting, unfortunately, working more on the issues of people with disabilities, because this is an area where we feel we need much more training ourselves. This unit in particular is already trained, but others need to be further trained. So we assume our own limitations. We focused on other groups and are now starting to get ourselves equipped. So it's also very good for us to be involved with you and cooperate, also looking forward to the materials that will come out. We manage also a national helpline, and we support victims in whole of Portugal. And I won't get to details of that, but just to give you a picture as well, we're involved with Victim Support Europe. We're part of Victim Support Europe, so we do a lot of projects international-wise. And some of the things I will also address have to do with our comparative experience with other countries. So information is, of course, the primary right of every victim of crime, as without it, no other rights can be effectively exercised. And in line with the provisions, in line with the provisions of the European Union Victims Directive, we speak of information here about information about rights of victims, about what they are and how to exercise them, about the proceedings they are part of, and about the support available. Recent international reports have shown that the main problem in the EU context is not information not being provided per se, although obviously there are exceptions here, but instead how it is provided. So the lack of means that are accessible to all, to different groups with specific needs, but also just in general with the simple language that victims can understand. And with the effort, which is also a part of the densification of the article itself, with the effort of making sure that the victims actually comprehend what these rights are, what rights they have. So there is a lack of guarantees that victims fully understand the information presented to them, thus preventing victims from making a good use of these rights. For example, in the Fundamental Rights Agency reports on justice for victims of violent crimes from 2019, they mentioned that 2/3 of the victims surveyed, for 2/3 of them, the information was difficult to understand, either because the language was complex or because it was delivered in a manner that they could not understand altogether. Although realities between the different countries diverge, it is clear that an effective provision of information is not yet a reality across Europe. With simple language adapted to the victim's needs, using diverse means of communication, and ensuring follow-up. And this is a very important point. That brings me to this idea that we have to move away from this duty to inform to the need to communicate, in the sense that we need to deliver information in a manner that a particular person can understand, including checking if that information was effectively comprehended and not just ticking a box. For the authority with the responsibility, be it the police officer or the magistrates or the forensic medicine experts or another authority in the local context. This is particularly important when we speak about particularly vulnerable victims with additional constraints to make themselves understood. However, before focusing on how to communicate, we have to think as well of selecting information we want to deliver. There's a lot of information that victims of crime should have access to. It is massive and it is sometimes very complex. We have to acknowledge that it is impossible for someone who has been a victim of a crime to retain everything that may be important to them all at once. So it's very important that the information is provided as needed at each point, without this obviously meaning any suboptimal delivery. So it has to be as well tailored. For example, a victim whose objects were not seized during an investigation has that right to know the return, or the right to return of property, but does not need it. So this is unnecessary. And this is an aspect overlooked, and that is very important when we consider the amount of information that the victim is exposed to. In fact, the more concise the information is, the greater the probability of effective understanding by the victim. These considerations are relevant to explain as well what we thought when creating the tools that I will show you shortly. We wanted to create a tool that we could explain to victims one part of this information that they ought to receive, which is the information on their rights, on the court, on what they will find in courts, what they will find in the different stages of the proceedings, and as well as what they can expect, how to identify the different actors. So I will try to share my screen with you now. 1 second. For some reason, not seeing the option. Share screen. Okay, apologies. So this is the web page. There is also a brochure. There is also a leaflet, a poster, and in the case of Portugal, the posters and leaflets are in fairly every police station and every courtroom, in every public prosecutor's office in the country. But as this was a transnational project, and of course we have pages in the language of origin and then in English for every country. I will use the Portuguese for ease of reference, but there are other countries with the same information. Yes, apologies for that. I can actually already put the version. So we have, I will show you on the version for visually impaired people, because a recent, unfortunately, this is in Portuguese. I don't know if it's well visible now. Sorry if I could, please let me know if it's not well visible. So basically the website was created with the idea of having information. I will translate because it's unfortunately only in Portuguese. To have information about the most common reactions for victims of crime when they suffer crime. And this is, again, there are obviously differences according to types of crimes, but these are the general reactions that might affect every victim for the fact that they were victims of crime. So for instance, the fact that the feeling of losing control over one's life, the associated feeling of guilt in some cases, as well as information about trauma, testimonies of victims, and tips on how to deal with the impact of crime. And then we have information about the rights of victims of crime that is provided as well with then links to other parts of the website. In this case, it's about reporting and the importance of reporting. Also an explanation of each stage of the criminal proceedings and who are the entities involved. So, and these are always with links that can connect one side to the other. So then, for example, we have an explanation of who is the police, what are the police forces and what the functions they each have, what are the differences, what they can do to help, what is their role in the proceedings. And then there's a section specifically on each person, on each actor and what their role is. And finally, unfortunately, it is not available on this version, but there is also a virtual courtroom where it shows who sits in each place within the courtroom. For instance, if we're in a hearing, then there are links as well to documents, and this is the sitemap with the whole information. This version of the website was developed more recently. It includes also the links of navigation. It was developed more recently under another project to try to bring more inclusion to victims, in this case with visual impairments. And there's also one version for victims who have hearing impairments. And this is unfortunately only for the Portuguese version. But the idea is to be able to expand that and also to have other versions that are necessary for other needs. But the information is simplified. So the idea was, without losing the accurateness of the information, creating a tool that would be easy to understand with a language that is a little simplified. Obviously, further simplification would be required, but it tries to break down a little in a tool that concentrates all the information. And this has been used by police officers and by public prosecutors to help when explaining further the information provided to victims. It is not a procedure. It is not an SOP, a standard operating procedure. Therefore, there is no effective guarantee that it's mainstreamed. However, the feedback we received was that it was well accepted by most of the authorities, and effectively utilized. We are actually conducting now an evaluation to learn lessons from this project that has been ongoing for a while and has been constantly updated, and hopefully improve it as a consequence. And this will obviously entail the interviews and assessment with victims who might use it and users who use it to search information about crime. There are differences between the different versions of the countries. However, they all have these 4 main sections, which is I was a victim of crime, consequences and reactions, rights of victims of crime, or the criminal procedure, who is who in the criminal procedure. And this is a very brief showing of this specific tool. I think I might have way more information that I wanted to discuss with you than I have time for, and some other resources, but I will try to concentrate a bit information. There's also another tool that we've developed with specific information for teenagers or for adolescents. And there is also a booklet that's also from APAV that I can also share the link with you. There's also an English version, but unfortunately there is no inclusive version made yet of that website. It's something that we have on the pipeline. And we have, and another material that I found quite interesting is not done by us, by a researcher that made cartoons for children who, in easy read, that go through the criminal proceeding to explain to them that basically reflecting on their feelings. So it's a girl that wakes up in the morning and is very scared because the day has arrived when she has to go to court, and sort of explaining to step by step what will happen on that day through this cartoon. And then a booklet for professionals dealing with victims in hearings specifically was made in combination with this comic book. That is also a very interesting tool. I would say that in Portugal, we still have a lot of we are still behind in many aspects when it comes to the inclusion of people with disabilities in terms of information in the criminal proceedings, but also I would say in terms of training overall of the different stakeholders that will eventually interact with victims. And there are no specific procedures established on how to implement a needs assessment for as foreseen in the directive and as transposed to national law, on how to communicate with groups with specific communication needs, aside from two very specific aspects with people with hearing impairments and for people who do not speak the Portuguese language. And the information that is provided to victims is still standardized, still not. There was an effort of simplification of the language, but no inclusive materials effectively developed, and the simplification also was, in our opinion, quite poor. There is. I will indeed share the cartoon. However, I have to let you know that unfortunately that's a Portuguese resource and I don't have an English version, but I can share with you for an example. I will leave the links or send to Paola for wider distribution, as you prefer. There is a growing acceptance of some figures that are very important, I think, particularly for victims with disabilities and child victims as well, with disabilities, but also without, which is now more and more the figure of the person of trust accompanying at every moment of contact with the criminal justice system is effectively being introduced. The problem that remains is the logics behind. So it is still very much connected to, very much focused on the needs of the proceedings, which is obviously a necessary part of it, but with less emphasis on effective communication. And this is where we lag behind in relation to other countries, I would say. But also another major difficulty for victims with disabilities, is the identification of vulnerabilities when they're not particularly severe, because the model of evaluation of assessments of needs is still very categorized. And finally, the way information is provided when victims are not being supported by either a victim support worker or an expert in court for accompanying victims in hearings, the way it's being provided, it's causing it's causing a lot of secondary victimization. And I will finish just because I know I'm overpassing the time, so I had a lot more to say, but maybe for the question session. But just one anecdotal situation that I think illustrates quite well was we had a case of a child with the psychosocial disability, and she was she had to go to, we have hearings that are, so when a victim of crime is a minor, by default, there's a hearing immediately that is used then in court without having to repeat to avoid secondary victimization. However, the girl did not know that the lawyer representing the defendant would be present and did not receive information on time, because unfortunately she was not considered with the opportunity of having a person of trust in that specific hearing. And this meant that she actually contradicted herself in that moment because she feared that that person was connected to the defendant, and so this would affect her safety. So these are situations that unfortunately still happen and have very much to do with the lack of proper communication of information to victims of crime. Thank you very much.
Anna, thank you so much. I can't say how impressive and comprehensive this information for victims is. And I think you'd be surprised, in many countries, there still is very limited provision of information, let alone really quality information that, as you've emphasized, has to be both understandable and timely. So I think these are the ways in which your work is really helping us, working with people with disabilities, to understand these factors as well. So I would like, thank you. I would like now to pass to Charlotte and David. They work with really a very interesting organization in the UK called the Advocates Gateway. And they provide support for communications for people with disabilities going through the criminal justice system. And this is a practice that I think is not so widely spread, but it seems to be developing. And I think the Advocates Gateway has some really great experience to share with us and with about how this service or this approach has been developed in the UK over the last, I think it's something like 10 years. So it's really, yeah, it's really interesting. And David, I would like to hand over to you.
Yes, Pamela, thank you very much. I'm going to provide the introduction, and then Charlotte's going to tell you about the intermediary scheme, which is there to assist communication, precisely the sort of issues that many people have rightly been raising already this morning. Can I first of all thank you for inviting us, and can I congratulate all of you on this initiative and all the hard work that you're putting into it in the various countries where you're based. I'm afraid I'm going to say how ashamed I am that I'm talking to you from England that isn't even a member of the European Union any longer, and this whole thing's being conducted in English. And you all understand these issues a great deal more than I can tell you. A number of English lawyers and certainly politicians understand it. The Advocates Gateway was started in 2013. It was co-founded by our chair, Professor Penny Cooper, as a free online resource to provide practical evidence-based. Evidence-based is a very important thing to remember. Guidance about vulnerable people in the courts. The most important resource there is the toolkits, which contain that practical evidence-based guidance. And the toolkits have been written and in some cases revised and rewritten over the years since 2013. and are used by judges, they're used by advocates, they're available to anyone. You can Google the Advocates Gateway and you'll find it. And in fact, the judge who is in charge of our whole criminal appeal system wrote recently, and I'm quoting from him, although great improvements have been achieved in recent years in the treatment of vulnerable witnesses and defendants, the Advocates Gateway and the toolkits continue to provide a quite stunning resource for the judiciary and practitioners. Well, he said it, so it's true. As I said, Charlotte's going to talk about registered intermediaries. I'm going to outline very briefly how we've got to where we are, what is available. If any of this is helpful to you in confronting local issues, all for the better. The key concept, of course, is that people are heard. That's something that's been mentioned already. And that means being heard by the police if they make a complaint, or to anyone to whom they make a complaint, and indeed the courts if it gets as far as that. As for myself, I practiced at the criminal bar for 27 years before I started being involved in legal training at City University. And I've written and spoken many times about vulnerable witnesses and defendants in court, and the duties of the advocates. We haven't touched on that, I think, very much today, but it's an important thing you've got to keep in mind as well as to how they treat witnesses when examining them. Now, that's terribly important in England because we have the adversarial system. That means that the witness gives their evidence in one form or another. We'll deal with that in a second. But then they are challenged or cross-examined by the other side because there are two sides. And it is, I say, of huge importance how that takes place, how they're treated. Language is an issue that people have been mentioned, all sorts of things which many of you already understand. So you really can't separate the experience of witnesses from the behavior of the advocate. We do have some training as to questioning. It's not huge, but it is there. It's voluntary because our criminal bar will not tolerate anything which they're obliged to do. But thousands of them have taken part in this training. The police have training before they're allowed to interview vulnerable witnesses, and those courses take place within the police. And the judges have training. They're not allowed to hear cases about serious sexual offenses involving vulnerable witnesses without attending training themselves. And that course has developed and improved over the years. The word participation is something which has really emerged only in the last few years. And it is, of course, of crucial importance, is the idea that a witness is participating in the trial when they're giving evidence, whether it's the victim themselves or someone else who can give evidence about it. But also defendants, and I'll get to the problem of defendants as well. But it has also gone, I should say, from the criminal system into our family and civil system. And they've now got onto the idea as well about the need to ensure participation for everyone, including those with physical and mental disabilities. So back to crime. In England, we began with the question of children. And in 1999, Parliament passed an act containing what we call special measures. That's a phrase I think Annie used. Special measures for children and for those with physical and mental disabilities who were witnesses, and their eligibility is all set out in the Act of Parliament. It did not include defendants, and that is a political situation in this country. Because the government said then in 1999, it was a Labour government then, and governments since then have made it clear that they are on the side of victims and witnesses. And even in the last week, when we've discussed the question of people who complain of rape, that the emphasis again is on them. There is no, as we say, there are no votes. There are no votes in saying a defendant should have a fair trial. So the protections for defendants that they can participate in their trial, which you might think is crucial, and which I think all of you have recognized, has really fallen largely on the shoulders of the judges, because the judge, first and foremost, has to ensure that the defendant has had a fair trial. That's a basic right. So the Act helps victims and witnesses, but there's also ways that defendants can be helped as well, both during their trial, so that they can understand what is going on as it goes on. And if any of you, of course, sit back in court, if you're not participating, and listen to the language which lawyers use with judges, that is not a language that ordinary people use. And if you're the defendant sitting through your trial, listening to that, it's quite clear they're not going to understand what is going on. And one of the things we did in our training for intermediaries, this is how I got involved in that, is we took them to court. We were very lucky in that, being able to do that. And we asked them to sit in the dock where defendants sit in court, where they're looking at everybody's back, except for the judge who's facing them, and say, how much would you think a defendant would feel they're participating in their trial? And that's even before we get to all the adjustments that can be made for people with disabilities. So what is available? Well, the important things that we've used from the Act is the use of screens. So the witness in court cannot see the defendant. And when I'm going through this, I take on board very much what Anna said. I was very struck by that a moment, that we've concentrated on this, possibly to the exclusion. We talked about protection, she said. Sorry, we've looked at special measures rather than protection, which is a very interesting concept, but these are the special measures. The use of screens, so they can't see the defendant. Giving evidence by live link. And what that means is that while the trial is going on, the witness or the victim is in a separate room in the court building, and they're communicating through the court by a screen, and the advocates and the judge in the court are able to ask them questions, and everyone in court can hear them. And there is a means as well for what we call remote live link, and that has been used, for example, people in care homes who can't come to court, and they're able to give evidence from there. So that's taking part in the trial live, but not actually in the courtroom itself, and obviously not. Though they have to be careful about this, not seeing the defendant, and there is a means actually to prevent the defendant seeing the witness if that's what the witness wants. Videoing evidence in chief. The police normally take a statement from a witness. There are lots of issues there, as you're all aware of the use of language and how the story comes out. But if it's not appropriate, then the police can instead record an interview. There's a lot of guidance about the right way of doing that and discussion about it. And then that is played at court instead of the witness going into the witness box and giving their evidence about what happened. The tape is played as the evidence in chief, and they are then cross-examined if they are a vulnerable witness, usually, of course, by the live link or behind a screen, very much what makes the witness comfortable. And then a further method of videoing the cross-examination itself, so that the whole evidence takes place before the trial. That was in the Act of Parliament in 1999. It's taken over 20 years actually to bring it into force. And there's a lot of discussion about that and its effectiveness. But that's the other method of doing it so that they get, they don't have to wait for the trial date. They can get it over with. The use of intermediaries, Charlotte will deal with that. There's also a provision in an Act of Parliament which allows the judge to say that the barristers have to take their wigs off if that makes the witness more comfortable. That's not something any of you have to worry about. So that's just an outline, and it's worth saying as well that over the years, while all this has been happening in the courts, we've developed criminal practice rules and directions. Those are all on the internet. Those have been drafted and revised by a committee of judges and barristers as a continuing process to keep it up to date. There's an equal treatment bench book, which advises judges on how to deal with vulnerable people and others in court. All of that is there for good practice. It's all been developed in the context of our law. I simply mention it because as things develop in your individual countries, you want to think about, of course, a body of rules and directions as to what is good practice, so everyone has that template in front of them. But the important thing, of course, is that everyone has access to justice and has the right to be listened to and to be able to communicate. And Charlotte will tell you about a very good way that they can communicate.
I take that as it's time for me. Yeah. Hello. Good morning, everybody. It's really great to be here. So what I'm going to do is talk in more detail about the work of registered intermediaries in the UK. Just to introduce myself before I get started, I'm a speech and language therapist by background, and that's very relevant to the work I do. And I've been a registered intermediary for about 12 years now. And my specialism is autism and learning disability, and I helped to write one of the toolkits that David talked about, which was about questioning people with autism. David touched on it briefly there, but the role of a registered intermediary is very specific. And what my job is to do is I'm there to support communication between witnesses and professionals within the justice system. What I'm asked to do is assess an individual and provide recommendations for questioning that individual. And I can be involved at different stages. I can be involved when the police are questioning that person, and I can also be involved when that person goes to court. What I thought would be really helpful, and when we were thinking about how best to present this, it felt that the most useful thing to do would be to talk about a couple of my cases. So what I'm going to do is I'm just going to share my screen, because I've done like quite a little PowerPoint for you just to sort of illustrate some of this. Now I'm just hoping that this works. Here we go. Sorry, I just have to. Now I'm hoping you can see that. Is that okay?
Yes.
You're nodding. Okay, great. So this is just to discuss some of the cases that I've been in. Both these cases are anonymized, so the names have been changed, and hopefully there shouldn't be any identifying information in there. And just to give a real sort of clear picture really of the work that an intermediary does. So just in general, to start with, part of my assessment is to really think about the individual's communication skills and in particular, really focusing on what their needs are and what might help them. So in general, the things and you have to really think about, well, and what might help them at police interview, which may be different to what might help them at court. Let me just think. So to start with, if I'm assessing somebody, what I would be doing is looking at these factors in general. And so I would be looking at someone's attention, their behavior and their emotional state. This is really key. And what strategies I may be able to put in place to support that. I would be thinking about their language understanding, for example, their understanding of different sentence structures, something called their auditory working memory, which is their ability to hold spoken information in mind and to analyze it for meaning. I would be thinking about their ability to use language, their ability to explain things, crucially, their ability to provide a narrative of an event. I would be trying to think about the different sorts of questions that they can understand and respond to. If that person has unclear speech, I would be thinking about that, and what strategies may be helpful to support the clearness of their speech. So like, for example, with going back to language use, I would be also wanting to think about the sorts of strategies that may help them explain. And for some witnesses, that might be looking at their ability to draw, to explain, their ability to use outlines of figures to talk about different body parts, for example, or their abilities to use more three-dimensional props. And the thing I'm always thinking is this helpful? Does this provide additional information? Because my job is to support communication to be complete, coherent, and accurate. So I'm thinking about that at all times. So I'm just going to talk you through one of the ladies that I've worked with. I'm going to call her Jenny. Jenny was, when I met her, she was 26 and she had a severe learning disability. I found out that she'd attended a special needs school. The police were exploring an allegation of rape, which was thought to have taken place, or there was an allegation made by Jenny's mum, basically saying that she walked in on Jenny and a family friend and in a very compromising position. And so she, given the severe learning disabilities of this lady, the mother contacted the police. What I did next, I was contacted by the police because they became aware very quickly that this person had a very significant learning disability and they wanted my help. So I went to the lady's house and I completed an assessment at the lady's house with the police officer present. Now I have to do everything with someone else present, and that's because I'm considered neutral, and everything I do has to be transparent. So there's no risk that I can be accused of telling Jenny what to say at another point. So the police officer was there. That also allows the police officer to watch my assessment, and because that police officer will then be doing the interview. In this particular case, it was really important that I thought about how Jenny could explain positioning of people, because that was what the mum had said. She said she'd walked in and she'd seen them in a certain position, and I guess the police officer was looking to ask Jenny about this and to see if that was supported by what Jenny said. So after completing an assessment with Jenny, it's quite detailed what I would do in that assessment, but my recommendations following that were that she needed to have a break after about 40 minutes for a cigarette. Her language the language that we used needed to be really short and really specific with no police jargon, because she did not say if she had not understood. What I learned in the assessment was that she used very short sentences, very, very short and limited, and her ability to explain position was very limited, although she could give some information. But what I established at the assessment is that she could use these things, so wooden mannequins, I'm just showing you one there, to help to provide additional information alongside her spoken language to explain position. And she really needed something like this to explain position in detail. And I also recommended that questions about things like times and dates would often lead to inaccurate answers. And I provided some recommendations about changing to question wording. And typically that's quite an often a recommendation that comes out from interviews quite a lot. If you're going to ask a question like how many times did this happen, it may lead to an inaccurate response, whereas we try and be more helpful and think, did this happen once or more than once, which leads to a more reliable answer, and then that can be unpicked accordingly. So I made these recommendations to the police, we discussed them, and I helped the police officer to plan the interview. And then Jenny was interviewed on a different day. She came to the police station And I was present with her while she was interviewed by the police officer. And at that point, if the police officer asked questions that were too complicated, what I was able to do was to intervene and help to rephrase the question, and so help to ensure that all her communication about what happened was received. And what in that situation, Jenny then was able, as on camera, as David reported, to provide very clear information that supported Mum's account of what she saw the mannequins provided additional information that through words alone wouldn't have been clear. Okay. So I'm aware that I don't have long, so I'm going to take us on to the case study number 2. Now this illustrates my involvement at court. So again, I've just picked a more recent example. This is quite a typical example of some of the work that I do, but one that is very memorable in my experience, and I probably will become clear as I go through it. So Liam, again, that's not his real name, was a 15-year-old boy when I met him. He had significant mental health concerns, and he was at very, very high risk of self-harm. He was living in specialist accommodation for children with behavioural difficulties. And why I met him was that he was due to give evidence in court at the trial of his mother. And this is what made it a slightly different case, because typically what we see is the defendant being the father or a male. And this was quite an unusual case in my experience, because it was his mother who was solely accused of sexually abusing him and his younger brother. Now, he had completed 2 police interviews at a much younger age, much younger. It took a long time to get to court. And a lot of his mental health concerns came out after those interviews. He was really, really clear. He did not want to go to court at all. He was asking, why do I have to do it? I don't want to do it. What happens if I don't do it? And he was very, very anxious, in particular about being seen by his mother, being in the same building as his mother. What I was able to do was assess him over several sessions to really be thinking about what would help him. First, I met him first at a police station. And then what I was able to do was to go with him, or I helped to arrange some pre-trial visits for him so he could go and see what would be in place for him, what things that would be there to help him feel safe. So he was able to go and look round both at the court building itself, and he was able to then go and look at a remote live link that, as David talked about, where he might be able to give evidence in a different building so he wouldn't have to be there. What that let me do is let me see him in different environments. Again, really helped me to tailor my recommendations. I was able to then realise things like, for example, that he hated being in rooms with no windows, and which was very specific about where he was going to give evidence. So just to give you a little bit more of an insight about how intermediaries might approach a case, especially with someone who was really anxious, what I did there is I wrote him a letter before I met him to just explain who I was. He's meeting lots of professionals, and it does, in my experience, really help witnesses to prepare themselves for meeting me and to know what I look like. I use this sort of visual approach to working with witnesses a lot. I might say this is me, but then at a later stage I might say we're going to go and visit court. I might send them a picture of what the court looks like, just so I can really help prepare for them for what's going to happen. And again, as a strategy to communicate with witnesses, I can't recommend it highly enough. So in this particular case with Liam, what I found that he was really, really challenging to engage with, and to develop a rapport with him was very difficult. He spoke very minimally on the first time that I met him. And that attention and behaviour and emotional state was the key thing for him. He did, however, have really good rapport with the staff that came with him, and he trusted them, whereas it was much more hard for him to trust me. He had difficulty paying attention. He was constantly fiddling. One of the things I think about was, how can I help this person stay calm? And again, I'm showing you something here. Something I might be trying is, would a stress ball help? Would a tangle chain help? And again, for him, those things were not helpful. And he made that very clear to me. What he said and what others told me was that he was at very high risk of self-harm, and when he wanted to hurt himself, he would look round the rooms, the building, look for sharp objects to hurt himself, and it would take several people to keep him safe, to restrain him, because when he was quite a big 15-year-old. And so when my language assessment suggested that he had difficulty with language as well, but again, that could have just been due to his high anxiety, but he had difficulty with his short-term auditory working memory, and so sentences did need to be very short. He wasn't saying when he hadn't understood something. His speech was clear. So what I was able to do was to explore with him how he wanted to give evidence, and he ended up well, what I ended up recommending was that he gave evidence via live link, which is again what David talked about, and I've just got a little picture of it there for you. That's how it looked. And what we were able to do is to ask that mum's view of the screen, of the live link screen in the main court, was also blocked, because typically sometimes if someone's in, it's often given to witnesses as a choice. You can either be in the court with a screen, and that means the defendant can't see you, or you can be in a live link room, but then the defendant will see you because you'll be on a screen. And actually we can combine those measures, but then sometimes that's not offered to witnesses. It can depend on the court as if whether they've got the physical means to be able to do that. Now in this particular court, that hadn't been allowed before. It was just thought of something that just couldn't be done, but I had to fight really hard, and actually the judge was able to agree to that. What I also suggested was that he needed to have a neutral witness supporter to be with him, because there would be no way I could hold him down or hold him back, shall we say, if he was trying to hurt himself. I'm not trained to do that, and he wouldn't trust me in order to keep him safe. So, and what I also recommended is that there was somebody outside of the courtroom who could come, or outside of the live link room, who could come in if need be. I recommended that the live link room needs to be checked in advance for all sharp objects, and these removed, and you'd be amazed as to how many sharp objects were in this room, and that we wouldn't have really thought about. What I suggested was that any questions that were considered motive, that they asked at the end of the cross-examination. I can't protect him from difficult questions, that's not my job. What I've got to be able to do is to facilitate the people in the court to be able to ask the questions that they want to ask, but I can think about how to do that. And my suggestion is that they're asked at the end, because if they were asked at the beginning, there was a chance that he would have disengaged from the rest of it, and then he wouldn't have got to the end of his cross-examination. And I recommended that there were certain question types not used. So, and again, this idea of something called a tag question, this you did, this didn't you, that wasn't used. And I had to justify that to the judge as to why. And questions to be asked one at a time, using day-to-day vocabulary. And so what happened in this case, the judge was able to come and meet Liam beforehand, which was really helpful, just to introduce himself. When all my recommendations were discussed and agreed in advance of his evidence, so we could make all the adjustments that we needed to in terms of checking the room and things like that. So the recommendations were discussed and agreed at this idea of a ground rules hearing. What I also did is the barristers provided me the questions in advance, and I was able to check the questions that were understandable from Liam's point of view, and I made suggestions to the wording and the sequencing. And then I was there in the room with him while he was questioned. And in particular there, I was able to, because I helped with the questions in advance, but what I was able to do is make sure that the pacing was right for him, that it was not too fast, and that I was able to help him with things like breathing, and which was challenging for him actually on the day. And again, he did actually give evidence at the end of it and gave a big smile at the end of it when it was all done. And the mum was convicted of all charges. So yes, I think that's probably the end of my presentation in terms of those case studies. I'm really happy to answer questions about. I'm going to stop sharing now.
Thank you, Charlotte. Thank you, David, and also thank you, Anna. I think this has been a real transition from hearing from Gabor and Anna about the broad, many of the issues and some of the challenge, or many of the very, very difficult challenges of providing the right setting and support for people to access justice. And I think you've, Anna, Charlotte and David, you've done an amazing job to show us some of the ways that that can be done. And I think some of the ways in which people can actively participate, can be heard, can be understood, and can understand what is going on. And I think what's also striking to me is that some of this is actually quite simple, and it's not expensive, it's not unreasonable. It just may not be very familiar. And I think that's really certainly very enlightening for me. So thank you very much. I want to ask if there are questions. I can see that Bruno has some questions, Stephen has some questions. Jofi, could I ask you to put Bruno on so he can ask in person?
Hopefully renovation will not disturb again, but so I got several questions, but I won't. There you go. Very quickly, for Charlotte and David, do you think intermediaries can have a supporting role for defendants as well?
Oh, they do. It began. Sorry, I sort of leapt in. Have you done an intermediary case, Charlotte?
I have not, but oh yes, a little bit for defendants and also in the family courts. But yes, it's becoming increasingly the norm, really, to see defendants with intermediaries. Well, David, you probably got a bit better overview.
Well, it began, as I said, because they'd been excluded from statute law, from Parliament, by Parliament. It's something that the judges had to develop because they suddenly realized that these people had disabilities and things inhibiting them having a fair trial, and something could be done. And so they started to order the use of intermediaries. There's a great discussion, I don't want to take up too much time on this in England, about whether an intermediary is needed for a whole trial, that is to help somebody all the way through it, or only when they give evidence, should they choose to give evidence. We could spend the rest of the seminar talking about that problem. They've been rather expensive, and they're thought to be expensive, but they have been there now for several years, and used. There have been some extraordinary cases where they have made an important difference in whether or not a defendant not only understood what was going on, but understood the charge. I remember one intermediary actually saying that the defendant, really by the end of the prosecution case, changed his plea from not guilty to guilty because of the intermediary's assistance. He actually began to understand, what had happened and what it was all about. No, there's a very important role for them to help.
Thank you so much. Thank you. I see we have some more questions coming in, thick and fast, actually. Bad as well. I think Stephen has a question. Stephen, would you like to go ahead?
Sure, thank you very much. And I just want to say thank you to all of the speakers. It's been absolutely inspiring to hear about the practices and the really concrete methods you've been deploying to improve access to justice for people. I have a very sort of specific question, but it comes up quite often in our work. Do you have experience of facilitating communication with victims of crime who are non-verbal or do not use verbal skills as their main form of communication? Can you tell us about your experiences with that, perhaps, Anna, Charlotte?
In terms of, I mean, more broadly speaking, there are intermediaries have facilitated communication with someone that might use alternative methods of communication. Absolutely. It's not the cases that I've been involved with where there was a question about that. What I ended up doing, I've met several, and I just think it might have just been luck, that some of the witnesses that I was asked to assess, part of my job is to say, do they have the communication skills in order to give evidence? And for some of these witnesses who were using alternative communication, for example, symbols, were at a very, very early stage of communication. And so part of my recommendation was, when I did meet them, was to say, actually, they don't have the communication skills to talk about something that's happened in the past. So it just so happened that those adults were using a PEC system, if that means anything, where they can exchange a symbol for a desired item like food. And so they were able to use a communication system to do that, but they weren't able to use a communication system to talk about an event that happened in the past. It's very much about their present needs. So that is another sort of key aspect of the intermediary role, is to say, you know, could we facilitate? And in those specific cases, I felt I couldn't, because their language skills were such that they weren't able to provide any form of information about a past event. But absolutely, intermediaries do work and with people who are non-verbal, those that use Makaton signing, for example, those that use communication books. It needs to be thought about very carefully in terms of how that's done, and because of the risks of possible being accused of leading. And it's, I mean, it's a whole day's training, but yeah, absolutely, it's possible.
I think there's recent, the intermediaries communicate with each other on their own sort of internet thing, where they swap stories and get advice and give help to one another. One recently is about someone who wanted to type her answers. I mean, that was one thing that certainly has come up in the past. And I just mentioned very briefly in this extraordinary case a few years ago of a victim who, a young woman from Pakistan who'd been trafficked into this country, used effectively as a slave by the family. She was profoundly deaf and had no language at all. And the deaf intermediary, we do have a few deaf intermediaries, had to begin by teaching her a language with which she could communicate, so that they first of all could find out what, if anything, had actually happened to her. And it was only then they could then get into the whole issue of it, and for her to give evidence at trial, which she did. It was a very long and laborious process of the deaf relay communication, but you know, the court had the willing and support to do it, and a rather very nasty set of defendants were convicted.
Wow, thank you, Charlotte. Thank you, David. That really shows what could be possible. Anna, would you like to add anything? Have you?
Well, I was actually trying to think. I knew of any case similar that my colleagues would have dealt with. My colleagues that do accompanying to courts and to police questionings, but not to my knowledge. So I wouldn't really need to ask. I don't have anything to add.
Thank you so much. Thank you. Thank you, Stephen, for the question. I know there are more questions coming. I think Julian has a question, and then after that, Maria. Julian, could I ask you to ask your questions?
Hi, are you hearing me?
Yes.
So in France, we struggle a lot because our psychopathology is still rivaled by psychoanalysis course. I wouldn't get into details because they sue for defamation when you say this association is a cult, etc. So very little the autism diagnosis is extremely low, and there is high institutionalization. And I just wanted to know if this webinar is going to be online, because it's recorded, and I couldn't find it on YouTube.
Thank you, Julian. I think it's not being streamed. but it's being recorded and we can make it available to you. Anna, Charlotte, David, would you have a response to Julian's point about the profession in France?
I'm sorry, I don't think I can. I'm afraid I don't know the French system. I apologize.
No, fair enough. Anna, any thought? I think Julian, maybe it's a really helpful observation for us to take on board. And I think to be sensitive to the fact that there are so many different systems and cultural norms and professional norms within countries. So we're very aware that certain practices are great, but may not be relevant.
In fact, maybe the only thing I could add here is sort of lateral, but I know that in terms of acceptance of the accompanying victims to court hearings, that France is one of the cases that has been identified in literature as with more difficulties to accept this the transposition of this particular aspect of the directive. So I unfortunately don't have more knowledge on the French system.
I mean, well, one of the things we've had here, and I'm sure everybody's going to experience it, is that the people involved in the courts, I suppose the advocates and the judges, although very determined and committed to doing a very good job, have the sense of we have always done it this way, and that it becomes the answer when you try to suggest something new. And the perfect example was when I talked about giving your evidence beforehand, taping the evidence. What they had always done was that the witness sat in a room and they played the tape in front of the court, in front of the jury. So the jury was listening to it as their evidence. And as soon as that finished, then they would be cross-examined. And it took a number of people to explain to the criminal justice system that the witness was watching this as a memory refresher, what we call, that is to remember what they've said. The jury is hearing it as evidence. So the witness doesn't have to be listening at the same time. And in fact, they might become upset when they hear themselves talking about what can be some very terrible things, or if it's a small child, they may not even recognize themselves in it. And that, in fact, they can watch it beforehand, and then the jury watches it, and then they do the cross-examination. That has now become the practice. But at the very beginning, judges said to me, no, the witness has to watch at the same time. We've always done it that way. So that's listen to that phrase, and that's, where you have to start.
And I think that is one of the benefits of the intermediary scheme is that we come at it from thinking about the communication, and there's a lot of questioning about, well, why is it that way? And this is the benefits of doing it this way. And if you can provide a practical alternative that it is cheap, as it were, or doesn't take much sort of adjusting, then we've been able to find, as this profession, we're able to sort of challenge quite a lot of these typical ways of doing things and sort of move things on.
And I would just add that furthermore is also the element of the building of trust and the comfort for the victim, effectively avoiding secondary victimization or reducing at the very least. So I think that's also and particularly when we talk about very vulnerable victims or defendants, it's even the more important.
Wow, thank you. We have 2 more questions. Thank you so far. I think Maria and then Edmore. Maria, could I?
Thank you, Paula. First, I would like to thank you all the speakers for the great insights they are providing us. It's really impressing. I'm impressed. And now I have a few particular questions, maybe to, I don't know, to Charlotte or to David, to all of you. Because we don't have that in our country, the intermediary accommodation, like at all. And it's something that we really need to have. And I was just wondering, okay, first, do you have, maybe Charlotte, do you have like, how is it regulated? Do you have like a limited time frame to establish a connection with the person, or like what period is that? If you are given like a certain period in which you are supposed to provide this to establish the connection and to provide the recommendations, or they're giving you like an unlimited period to establish that connection? How is it regulated?
Oh, gosh, that's lots of questions. That's why. So in terms of regulation, there is what we call the intermediary scheme has a quality assurance board, and that does deal with any complaints that are raised against intermediaries. I think there is an argument that it could have better regulation at the moment, and I think that is something that's always being looked at. As an intermediary, we are meant to produce yearly proof of our CPD and things like that. So there's some oversight, but I think it's likely to change in the next few years for various reasons. In terms of the time allotted, typically, in most cases with intermediary work, you are typically doing an assessment usually in one session and then doing your sort of facilitating communication in another. But that's not, you don't have to do it that way. It's just typically that's, if you're well prepared, if you've done your background information, if you've spoke to carers in advance, you don't often need more than that in order to, but of the case I gave you, that was more challenging in the sense it did need more work. Developing rapport was more challenging, but I just needed to get to the point where my rapport was good enough. It didn't have to be amazing, it just had to be good enough. And actually, there is no cap about, we are funded by either the police for the interview or by the CPS for the court work. I think there's no kind of, you can only spend an hour with this person, you only spend 2 hours with this person, but you just have to be sort of discussing it with them in terms of, I'm going to suggest that we do another visit, I'm going to suggest that we do this, and this is why. Again, whether that will change in the future, I just don't know in terms of whether there were, I don't know, but I think it feels like we're at the moment, if we feel that we need to do more in terms of developing rapport, that normally feels that can be accommodated. But yeah, that might not always be the case.
Thank you, Charlotte. I'm going to move on a little bit quickly because we're coming to the end of our time, and I would just like Edmore to have a chance to ask his question as well. Hi, Edmore, could you put your question to the panel?
Hello, I had written down my questions, which are how has COVID-19 affected your work, and how will the recent practice rule affect the provision of intermediaries for defendants?
Thank you, Edmore. Did everybody catch that?
Cool. Yeah, I believe. On the, I think there was a specific question for intermediaries.
About the effect of COVID-19, yes. Yes. Yes.
That one I can also say something about. There is a lot.
In terms of intermediary work for COVID, yeah, it has affected it awfully, yes. In terms of the additional, maybe needing a mask, which of course for someone with communication needs can be really, really challenging. You're interviewing often in a small unventilated room. It has, yeah, huge additional problems. Yeah, I can't say it's very, very difficult, and cases getting delayed. I can't think of anything positive to say about it, really, in terms of, yeah, very, very challenging. But I mean, we're trying our best, but a lot of the things that we try to do are not the same as that they would be in non-COVID times.
Thank you, Charlotte. Anna?
Yeah, so I think this question was more specifically on intermediaries for defendants, but maybe I can just say just very overall, in terms on the side of victim support, the way it affects, first of all, it affects people, it affected victims, and particularly the most vulnerable that became even more vulnerable. So they more, I would say, more invisible as well, more difficult to access support in general. But also the number of cases of violence rise quite substantially in different types of violence. And in terms of the services, I think everything changed to online very much. And one interesting silver lining of the pandemic, though, I gotta say, is that the usage of teleconferencing and court hearings became mainstream. So that's the only change for the better, the acceptance change in mentality for it. But other than that, the impact was quite severe on the lives of people, on the incidence of crime, and as well on the way that we had to adapt to be able to reach people and provide support.
Thank you.
Can I just add as well, I'm sure everyone has been in this position as well. The whole criminal justice system, of course, stopped for a couple of months, and there's a huge backlog of cases, and that has presented the problem for everyone, of course, is that they now have to wait so long for the trial to take place, and I think we can all understand the effect that has on the witnesses.
And many times there were already long waits as it was. So
we know that the impacts also on children are particularly acute. I just want to say thank you all very much. I think there would have been a lot more we could have pursued and talked about, and I hope very much we can continue these conversations actually in the future. This has been extremely enlightening, I think, for all of us. But we have reached the end of our time, so thank you. And yes, we have another session tomorrow from 11 in the morning, when you're very welcome to join again.